Okay, Chapter 12. The last thing that we want to make sure before you start doing clinicals, and especially if you are taking care of clients that have any kind of issues, whether they are medical or whether they are physical, is that we adhere to the correct ethics, that we make sure that we take into consideration the client's rights, and that we make sure that we review any legal and forensic issues that are included. First, ethics. What is ethics? Well, ethics is actually So what are the principles of bioethics? In nursing, it includes autonomy, beneficence, fidelity, justice, non-maleficence, and of course, veracity. So without going into lots and lots of detail for all of these, we do want to make sure that we touch on each one of these. Autonomy, this is freedom to choose a certain course of action. In other words, to decide what is best for us and to actually act on that choice. Understanding that we're going to have to live with those consequences of that particular choice. Helping clients and families make good informed decision helps to support that autonomy. We need to give them information that they need in order to make good decisions. Beneficence, this is the principle of doing things that benefit others in order to promote the good of others. We do this when we help clients who are not able to decide for themselves, or who are incapacitated, or who may even be incompetent. Fidelity, this is maintaining loyalty and a commitment to your patients. You have to be faithful to your promises, to the things that are duties and even obligations as far as your clients are concerned. It is crucial to establishing trusting relationships. Do not make promises that you cannot keep. This is everyday life, not just with clients, but it is especially so in someone who has a mental illness. Justice, this of course is the principle of treating others fairly and equally. Doesn't matter what the color of their skin is, what their socioeconomic status is, it is doing the same thing for one person that you do for everyone. The things that are fair and that are equitable are distributed as far as the burdens and the benefits when it comes to clients. Principles of justice always raise questions about these things. For instance, should indigent persons who are schizophrenic be treated with older traditional meds with uncomfortable side effects, but those that can afford to be treated with newer and costly psychotropic drugs have fewer effects? That's not how we should decide that, is it? It shouldn't matter whether or not that someone has insurance or whether or not that they're able to pay for it. However, realistically, if we put them on medication that they don't have a support for, in other words, it's not being provided for them, or that they don't have some sort of assistance, the likelihood of them staying on those medications are poor. And on the flip side, even patients that can afford the expensive psychotropic drugs, if they decide they're not going to take them, it doesn't matter how much money they have, right? Second, is insurance coverage for psychiatric or mental health services a basic service or a luxury? I will tell you that from personal experience and having insurance that does not cover mental health services, I think that this should be a basic service. Is mental health the same as physical health? Well, when it comes to insurance coverage, it should be. You can be physically debilitated, but you can also be mentally debilitated. Both of them that can cause significant health problems. Both of them can lead to disability and even death. So And third, should mental health care be given to those who need it or only to those who can pay for it? That most certainly in this country happens to be a problem as far as justice is concerned. Patients that require drug treatment or patients that need to have intensive treatment, the only individuals that really receive that are the ones that can pay for it out of pocket. Most insurances are not going to pay for that, and most individuals are not going to have access to that unless they do have money. What's I never can say this right. Non-maleficence. This is the intention to do no wrong. The intention to do no wrong. Your motives for action should be in the direction of helpfulness. It should be based on sound knowledge of psychiatric mental health theory. It requires you to be self-aware. And of course, it is a principle behind the self-awareness features that you see in your textbook and throughout the text. Veracity simply means the intention to tell the truth. It is critical in establishing trust with clients and their families and other mental health care workers as well. If you cannot be trusted to do what you say that you're going to do or to tell the truth, you can't be depended on. What you do and what you say will be open to suspicion. Ethical guidelines for psychiatric mental health nurses. Remember that clinical judgment and ethical reasoning are very important. Psychiatric mental health nurses are frequently faced with the following two goals. 1, responding to the therapeutic needs of an individual, and 2, serving society by preserving social order. Ethical dilemmas. This is something that nurses in general don't like to have to deal with because most nurses are going to view them in a different way depending on the situation and, again, their personal beliefs. Nurses have to be agents for both the agency and for the client. That is very important. The professional and the client are from different cultures, and they may have different values in some instances. Sometimes the voluntary nature of the client's participation is compromised. The client's competence to enter into an agreement about intervention is questionable at times, or the client may not realize that certain interventions are being implemented. When this occurs, you're going to have ethical dilemmas. Sometimes you have external factors. Maybe there's a lack of time, maybe you have a lack of staff, or even high demands that are going to prevent the professional from doing what is best for the client, creating what? An ethical dilemma. The ones that you have listed above, like the use of restrictive treatment interventions and the client's right to privacy, these are ethical dilemmas that we come into contact on a regular basis. The ones that I just named are ones that are not probably quite as maybe I should say obvious. They're certainly there, and they certainly are dealt with, but they're not quite as obvious as the ones that I have listed above. Stigma that's associated with diagnostic labels. This is tough. It's really important that we use, or that we try to avoid using arbitrary, or what I like to refer to as oppressive labels. Don't use stereotypes. Just because that you have seen this before doesn't mean that it's the same in every individual. Okay? Labels themselves, when we do diagnose clients, this helps us to decide on treatments and meds, and it makes it easier to communicate about a client, but it's not, there isn't really truly a need for diagnostic labels other than to help to develop those treatment plans. And then of course, a nurse's moral stance. Do you think that labeling psychiatric diagnosis is simply to provide psychiatric professionals with some additional sense of control in their dealings with clients? Do you think that's why that we give that we do this labeling? Do you think it's true that a diagnosis gives staff members an increased sense of being able to predict client behavior and a way of calmly viewing what might otherwise be upsetting behavior? For example, that's just her hysterical personality coming out, or those complaints are just paranoid delusions. Those are stigmas that oftentimes are associated with diagnostic labels, and we need to really be careful about using them because they can actually cause more problems than fix problems. control of individual freedom. Violence against others. It's important that these individuals are able to balance the value of life against the value of liberty. So is it more important to maintain their freedom, or is it more important to value life for these individuals? What about suicide? A person without a mental disorder would not choose suicide, would they? How do they define quality when it comes to life? Is the definition limited to physical factors? Do they feel like that their quality of life is based on whether or not that they're able to hold down a job, or whether or not that they are able to exercise or get outside and do different things? Is their physical condition limiting them as far as the value that they place on life? Psychosurgery is another control of individual freedom. This is surgical removal or destruction of brain tissue with the intent of altering behavior, even though that there might not be any kind of direct evidence of structural disease or damage to the brain. What is this called? This is called a prefrontal lobotomy. I used to do this a lot. Advocates of selective use of psychosurgery, even against the client's will, outline the following 3 conditions that must be met in order for this to occur. The illness has to be treated seriously, has to be labeled, as being seriously disabling and untreatable by non-surgical means, such as medication or even psychotherapy. 2, the treatment has to be undertaken with some sort of systematic investigative protocol, so it's going to be accompanied by evaluation research. And then 3, the treatment is going to occur in settings with as many safeguards as possible to arrive at informed consent. If possible, perhaps using a client advocate during the procedure. And then 4, psychotropic medications. We use these very cautiously. We use these judiciously. We don't just throw these out like candy. The goal is not to drug or to dope up a patient. It is to control the symptoms so that they can function in society and, of course, at home. And restraints, we try to use restraints as little as possible because they do often have a negative and traumatizing psychological impact on the client. It is perceived by the client, no matter what you think, as being unethical. All judgments that are made about restraining patients are going to involve moral decisions, such as what other techniques have been tried prior to doing this. Is the client obviously that out of control? How does the nurse decide when the restraints are necessary, and is the patient cognitively compromised? What will the effects on the client be for such a dramatic intervention, and what are the effects on others in the milieu? Remember that patients are going to be witnessing this to a certain degree. Clients will see you put someone in restraints, or they will most certainly see you taking them out of the general population. So this does definitely has the potential to cause some problems. Client privacy and confidentiality. Clients may reveal highly personal and sometimes even embarrassing or potentially damaging information about themselves when they come in to see you. We understand client privacy and confidentiality. We understand HIPAA. However, sometimes we need reminding about this, especially in mental health, because mental health nurses oftentimes need to be able to decompress or need to be able to talk about the stressors that they are experiencing within their milieu. Nurses usually have to give any type of information that it could be especially damaging, or even just information that is directly related to the patient is going to be given to the psychiatrist, right? And the only other people that should have that are people that are directly caring for that patient. There are 3 different ways in which we are going to attempt to provide the client with privacy and confidentiality. One of them is to convey to the clients that the limit of confidentiality in your exchanges. That is what you do with the information the client shares. I'm only going to share this with the psychiatrist. I'm only going to share this with your counselor. Okay? I'm only going to share this with the nurses that are caring for you. I'm not going to be telling the pharmacist. There's no need for the pharmacist to know those kind of things. Two, we want to attempt to portray accurately to others the reliability, the validity, and the representativeness of the date that you communicate about a patient, about a client, excuse me. And then three, recognize that strict confidentiality may have to be violated when an innocent third party is endangered, but only if that individual, if that third party is endangered. Mental health status. There we go. Sorry, guys. Mental health status and regulations. There are certain rules and regulations that are going to be set by state governments that must be adhered to. They're going to vary from state to state. Nurses that practice within this area need to know the laws of each state that they happen to practice in. What is voluntary admission? Clients may have to be given written notification of their intent to leave during a grace period of anywhere from 24 hours to 15 days. Voluntary admission requires informed consent. The client is going to retain all of their rights, and of course the client has a right to demand and obtain release. However, as I said just a second ago, in a lot of places in the facility that I work at, it requires them to have a 72-hour period of notification. Involuntary commitment is a little bit different. Involuntary commitment means that this individual was placed in the hospital against their will. What's the criteria? Well, it's going to be done in an emergency situation. It can be temporary or it can be observational. In other words, they may have come in and they were voluntary, but we feel like that based on their actions, their attitudes, their overall demeanor, that they are a threat to themselves. And so we may obtain what we call a temporary order for them. It can be extended or it can be indeterminate, and it can even be outpatient commitment. Some clients may actually be kept anywhere from 5 to 7 up to 150 days, depending on what the court and what the physician may feel is necessary as far as involuntary commitment. The criteria for involuntary commitment is of course going to be that they're a danger to themselves or to others, that they're unable to provide for basic needs, and of course that they are acutely mentally ill. Discharge or separation categories. Discharge is going to be conditional in some cases, meaning that they may come back to the facility if they don't meet certain conditions, like not going to see their mental health worker, not going in to get their injections like they're supposed to. Or it can be what we call absolute, which is a new hospitalization would be required before every admission. We would have to evaluate them before they were put back in the hospital. So this would be considered an absolute discharge. Those individuals would have to go through the whole process of seeing whether or not they even meet criteria to be admitted to an inpatient facility. A transfer, and a transfer can mean that they are maybe taken either from an acute care facility to an intermediate care facility, which is kind of like a group home or a halfway house. They may need to go to a long-term care facility because of behavioral disorders like Bryce, or they may even go back to actually being transferred back even into jail, incarceration. And then of course you have escape, which is can be because of elopement. So they actually get out, or they can be AWOL, in other words, not showing up to where they're supposed to be. Maybe they were scheduled to report to inpatient treatment and they don't show up. That would be considered to be AWOL. All right, in your book on page 229, it's box 12-1, are reasons for raising an raising an insanity defense, which is going to be part of psychiatry and criminal law. Psychiatry and criminal law is actually determining legal sanity. They might be guilty, but they might be mentally ill. They can have a diminished capacity, or even this is to determine whether or not that they are competent to stand trial. Diminished capacity simply means that this is an element of the insanity law that refers to an individual's capacity to form the intent to commit a specific act. There are 4 levels of intent. It can be purposefully, it can be knowingly, it can be recklessly, or it can be negligently. And then as far as competence to stand trial, no person can be tried if they are incompetent. The capacity to understand the proceedings and to assist one's attorney has to be determined prior to that. And if they are found to be incompetent, they simply will not be able to be put on trial. Psychiatric forensic nursing. This is defined as psychiatric nursing assessment, evaluation, and treatment of individuals pending a criminal hearing or a trial. The setting is, of course, the crime scene, the courtroom, or even the forensic treatment setting even actually up to a correctional facility. This is what's going to influence the forensic nurse's practice. Role credibility means that these individuals are going to be highly skilled in interpersonal relations and communications. They've got to have a graduate degree in forensic nursing. Sexual assault nurse examiners have a certification exam through the International Association of Forensic Sciences in order to be able to practice this type of nursing. They must have a collegial relationship from other disciplines such as forensic science, criminal science, and that's just because that they overlap each other. A forensic examiner is going to conduct court-ordered evaluations of legal sanity or competency to proceed. He's going to answer any kind of specific medical legal questions as directed by the court, and he's going to render an expert opinion in written report or courtroom testimony. These nurses are going to have separate personal opinions from professional opinions, and they are going to isolate personal feelings when it comes to dealing with cases of criminal violence. The forensic examiner's expert opinion is going to be based on scientific processing of things like the collected pertinent clinical data, so what they actually are able to collect, what they observe by the client, any kind of forensic evidence that they find in police reports and lab reports, the results of any kind of psychological testing, and they're going to have done a thorough psychosocial history as well. A competency therapist is actually going to, through the administration of assessment tools, is going to do an assessment of competence as far as mental disorders are concerned. They're going to do a forensic interview, and then they're going to document the client's progress towards competence. They're going to complete formal reports for the court, and they may also serve as expert witnesses. An expert witness, as an RN, you can actually be subpoenaed to court as a fact witness. In other words, to tell what you saw, did, what you heard, etc. An expert witness, however, is recognized by the court as having a high level of skill or expertise in a designated area, and this is for the purpose of being able to render an opinion on a legal matter in court. Expertise is, of course, established by your credentials. It is also established by trustworthiness, the degree of honesty that's exuded in your demeanor and your opinion, and this is as the judge or the jury actually perceives it. The way that you present also has a lot to do with being considered an expert. How you come across to others, you have to be able to communicate in a concise and convincing fashion. Consultant to attorneys, this is a resource for education and information about mental illness. They may attend the hearing as an observer who listens to other witness testimony in order to further provide cross-examination guidance, and they can help in preparing for the trial. And then a consultant to law enforcement. These individuals are going to focus on criminal profiling and even hostage negotiations. They're going to give suggestions on how to interview a subject, and interestingly, Over half of all hostage incidences involve hostage takers who are classified in law as mentally disturbed. Correctional mental health nursing. This is not an area that I have a great desire to work in. But this is an area of mental health nursing that is done simply for inmates that are housed in a jail or even in a prison psychiatric unit. Can be, in addition to that, can be in a forensic psychiatrist hospital or in a long-term ward. They're going to perform psychiatric nursing skills rather than forensic nursing skills. They're going to provide care, treatment, rehabilitation, and management of individuals, but it's going to be done in a secure facility that's going to have a much higher level of safety, and these individuals are going to have been deemed or labeled as legally insane. Let's look for just a minute at clients' rights. Clients have the right to informed consent, meaning that they have to understand the treatment process. This helps them to be able to make sound decisions. They have the right to treatment. The loss of liberty for the purpose of therapy, then failing to provide adequate therapy, actually violates our constitutional rights. All clients also have the right to refuse treatment, especially when the treatment has side effects. The right to treatment in the least restrictive setting also provides care with maximum personal freedom. Half the states that we looked at actually require the client to have access to writing materials and postage. So this is going to affect their overall right to communicate with others. The right not to be subjected to unnecessary mechanical strains. Restraints are used less frequently. However, we do use seclusion on occasion. This is for the prevention of harm to self or others. Some of the early interventions, though, in order to maybe bypass some of this or be able to eliminate some of this, could be done through active listening or even the judicious use of PRN meds, giving meds to help to stabilize them as far as their anxiety or even anger outbursts are concerned. The right to privacy. We said earlier that these individuals have a right to keep personal information a secret. The client may need to sign a release of confidentiality, especially in the case of a car accident or of an overdose. Insurance can get information about a client's treatment in order to pay for charges. So it's important to know that some individuals are going to have to be granted a right to some of the things that you consider to be private. Privileged communication. Privileged communication is a very narrow concept when it comes to the right to privacy. It was established by state statutes to actually prevent and protect possible incriminating disclosures made by a client to specified professionals, like between a husband and a wife, admitting that they've done something that would get them incarcerated or get them in trouble. The same thing goes with what they say to their psychologist and to another client. Each state that grants privileges also specifies exceptions to that privilege, so it is going to vary from state to state. The right to, under the right to privacy, you're also going to have what we call disclosure of safeguarding others. This just simply means that mental health care professionals have a responsibility to balance confidentiality with what we call a duty to warn and a duty to protect. And then lastly, you need to make sure that you read over your intervention strategies that are on page 238 when the right to privacy can be breached, so that you understand that when acting in a client's best interest in an emergency situation, this is a time that the right to privacy can be breached. It can be breached when acting to protect third parties. It can be breached in child custody disputes and when you are reporting child abuse, gunshot wounds, or even contagious diseases as required by the state law. The right to periodic review of status. actually should occur every 30 days in some states and yearly in others. It protects clients from spending more time than necessary in the hospital. And then lastly, the right to independent psychiatric evaluation is the right to have independent psychiatric assessment by a physician of their own choosing. So we can't always say this is the only person that you can see, or this is who you're going to have to go to if you want to receive treatment. Client rights, they have the right to participate in legal matters, including making a valid contract, executing a will, marrying or divorcing, voting, driving a motor vehicle, practicing a profession, suing or even being sued, management of or disposing of property. Just because someone has a mental disorder does not mean that they do not have the same rights. They have the right to habeas corpus. Habeas corpus simply means that these individuals will receive a speedy release of any person who has been illegally detained. So if we keep them and we have no right to do that, they have a right to be released as quickly as possible. If the client is found sane in a hearing, then the client must be discharged. Of course, they have the right to legal representation, and they have a right to keep their clothing and personal effects as long as they do not pose to be any kind of harm or danger. They have the right to religious freedom. They have the right, of course, to education, and they have the right to civil service status as well. What about children and minors when it comes to rights? If they're under 18, then of course they are considered legally incompetent. Not that they are truly incompetent, but they are simply not able to stand alone, to be able to stand up for their own rights. They're going to have someone to be able to intercede for them. This is going to include legal consent for medical treatment, but the following exceptions are going to occur, especially if they should need treatment for drug abuse. Of course, the consent to contraception or abortion if they are actually under the age of 16, and then of course to seek psychiatric treatment. Psychiatric advance directives. These are legal instruments that allow competent persons to document their preferences regarding their mental health treatment. Clients who expect to become incapacitated, like individuals that have Alzheimer's, they may refuse certain medications or treatments, like having ECT or even psychosurgery, and they have the capability of being able to appoint a trusted surrogate in order to make decisions for them in the event that they're not able to. So these are different than advanced directives as far as your health, your physical status is concerned. They are specifically for your mental health treatment. All right, what about liability in the mental health psychiatric nurse? You can have criminal law, which pertains to the behavior that's considered to be a threat when it comes to society as a whole, things like murder, assault, and robbery. You can have civil law, which is concerned with the legal rights and duties of private parties. Most legal actions against nurses are going to be civil actions. The tort law, which is actually a wrongful act that is resulting in injury for which the injured party files a civil suit, and that is requesting legal redress. In other words, they want it looked at in the form of monetary damages. Torts can be intentional, as in assault and battery, or defamation of character or invasion of privacy, even for individuals that they feel like have been put in prison falsely, for fraud, misrepresentation, or even unintentional, as in negligence. This is why we have to have malpractice insurance, is simply because of the tort law. Negligence is used whenever a nurse fails to act in a manner in which most reasonable and prudent people would act, or when a nurse acts in a way that a reasonably prudent person would not act under similar circumstances. And then malpractice, these are negligent acts of healthcare professionals when they fail to act in a responsible and prudent manner when it comes to carrying out their professional duties. Make sure you document Remember, we said that this is especially important if you are involved in some type of a malpractice case. In your book, you have this that this box 12-3 is actually used for determining negligence. Make sure that you review this. Make sure that you go over it, and if you have any questions about it, make sure that you ask about that. Things like contract for care simply means that this begins when you accept a patient assignment. Okay, it offers information or education, providing treatment, etc. Those things. Duty of care, or what we call good faith. This is, of course, use of the nursing process. Ignorance of a policy or procedure is not acceptable. It's not acceptable rationale anyway for not following a policy or procedure. You can't say, I didn't know about it. It is your responsibility to know about that. Boundary violations. What is that? In this, boundary violation simply means that nurses do not form social relationships with mental health clients with whom there is or has been a professional relationship. This is unethical. Does it happen? Sure, it happens, but it should not happen. Common sources of liability. Client suicide, of course, improper treatment. You will find a list of these also in your book. Make sure that you review them as well. Client advocacy. All patients have the right to be represented by someone that is looking out for them when it comes to their mental health. This oftentimes is the ombudsman. It was developed by states, and they are people who speak for, or as we call it, champion for the cause for others. And this is not just for psychological abuse of clients, but also for physical. You will hear about the ombudsman where in healthcare facilities, especially in nursing homes, we see a lot about ombudsmans. Advocacy interventions, and of course a duty to advocacy interventions would include things like the unsuitability of certain staff members who don't have patience or the understanding to work with clients, having problems with control, or a buildup of stresses that have reduced both the staff's patience and the ability to problem solve, like burnout. And then, of course, an actual lack of knowledge or other means of interacting with clients in a high-stress situation. This would be a need for having advocacy interventions. Other areas of advocacy would include educating clients and their families about their legal rights, monitoring treatment planning, and of course the delivery of service for the abuse of clients' rights. Evaluating policies and procedures, making sure that that patients are provided what is expected, making sure that clients have necessary information to make informed decisions, questioning other healthcare professionals when their care is based on what we consider to be more stereotypic ideas than on the assessment of the client's needs. So instead of doing that thorough assessment, we're just saying, well, this is what we did for Mr. Jones, so I bet it'll probably work with Miss Anderson too. Making sure that we're speaking out for safe practice conditions, especially when it's threatened by budget cutbacks, and then of course supporting private advocacy organizations such as the Bazillion Center for Mental Health Law that actually defends the rights of children and adults who have mental disabilities. And then duty to intervene. Sometimes it is hard to know when you should intervene. Am I going to get sued if I do this, or am I going to get sued if I don't? Have to make sure that that you pick the right time and that you actually involve yourself to the right degree when it comes to intervening, and understand that there may be that this may be a long drawn out thing, or that there may be some results that may be difficult to handle. All right, lastly, let's go over resources real quick. These are some good resources for you when it comes to looking over the ethical aspects of this. Resources: the American Academy of Forensic Sciences. This is just the American Academy of Forensic Sciences is a professional organization that provides leadership to advance science and its application. the American Academy of Psychiatry and Law, and the Seclusion and Restraint Position paper. This site actually contains a downloadable file of the APNA Seclusion and Restraint Position paper. This is an interesting paper. Would really benefit you to take a few minutes to read this. And then, of course, the Mental Health Bill of Rights. This site actually contains the APA's Mental Health Bill of Rights itself. All right, that concludes the end of Chapter 12.